Welcome back to the Ohio Farm Bureau podcast. I'm Ty Higgins. Congress passed the Corporate Transparency Act in 2021. It will officially take effect on January 1st. Among other things, this new CTA requires that millions of businesses report their ownership to the Department of Treasury's Financial Crimes Enforcement Network and could provide a burdensome reporting requirement for ordinary entities operating legitimately. To talk more about this from Wright and Moore is Ryan Conklin and Jonathan Cottingim. Great to see you guys. Jonathan, first time on the podcast, so great to meet you and looking forward to the conversation.
Good to see you as well, Ty. Thanks for having us.
Jonathan, new to the team. Good to see you and meet you for the first time. This topic, though, pretty serious for many Farm Bureau members out there. First, let's talk about what the main purpose of this Corporate Transparency Act is.
Yeah, so the purpose of the act on its surface wasn't a bad idea. The Department of the Treasury was trying to get a little more information about how small entities and small businesses in the United States are working. The attempt here was really to kind of cut down on tax fraud and to increase transparency, hence the name, between how our businesses are operating, who's owning them, and kind of trying to make sure that the taxes are getting filed correctly.
Ryan, what are the odds that a member of Ohio Farm Bureau is subject to the CTA, and how would they find that out?
Yeah, Ty, for many of the Farm Bureau members who are listening, they might be operating already within a partnership or a corporation or an LLC. The Corporate Transparency Act was designed to capture some of these very small businesses. So if you're operating within a formal entity or potentially even an informal entity, like a father and daughter or two brothers that are farming together, just splitting grain checks, you might be considered an informal partnership, which would be enough to trigger that formal business entity structure that would be captured by the Corporate Transparency Act.
Jonathan, any exemptions for filing?
There are lots of exemptions, I think close to 36 at this point. The problem is for most of our members here at Farm Bureau, they involve heavily regulated industries primarily. Think banks, insurance companies, things like that. There is an exemption for larger operating businesses that a Farm Bureau member could potentially fall into. It requires you to have 20 full-time employees, a tax return of at least $5 million for last year, and you have to have a physical office that you operate out of here in the United States. So that exemption is available to some members, but it would probably be a rather small percentage.
So Ryan, let's say none of the exemptions apply to you. What do we need to report to the Department of Treasury, and how do you file that report?
It could be a very intrusive or very informing report that a member would have to submit in order to comply. So the Financial Crimes Enforcement group there within the Department of Treasury is still rolling out the website to complete the reporting requirements. But we're talking about information such as the name and percentage ownership of the members, address, tax ID numbers, so social security numbers as well. And really, this is tied in with Jonathan's point from earlier. What we're trying to sniff out here is shell companies, money laundering, financial crimes that happen. So what we're trying to verify is that each person that's part of these businesses is actually a U.S. citizen, legitimate citizen that is operating this business correctly.
Jonathan, the deadline to report depends on when the entity was created. If it's been around for a while, you might have a little bit more time.
Right. So if the entity was created prior to January 1 of 2024, they have until the end of 2024 to file those reports with FinCEN. Anything created next year, so starting on January 1st, if you create a new LLC or a partnership or any type of entity like that, you'll have 30 days as of now to file your reports. There is some stuff in the works to try and get that 30 days extended to 90. As of now, we don't know whether that will happen or not. So the safe bet would be to count on 30 days. Going along with that, any change in ownership has to be reported within 30 days, whether the entity was created prior to 24 or after 24. So if you gift any interest or if you sell some ownership of your business next year, we're going to need to get that filed pretty quickly.
Ryan, yet another example, no matter how big or small your farm is, to have a team of experts there to help you out through these.
That's right. Having good legal counsel and good tax counsel who can keep you up to date on these changes in the law is very important. And I think they're going to be important here in 2024. As Jonathan was mentioned, getting into compliance for your existing entities and also your new entities. But something for members to watch out for is kind of unsolicited mail that might be coming from third parties saying, "Hey, we'll help you comply," or you got to pay us X amount in order to come into compliance. A lot of the times those aren't they're legitimate businesses, but they aren't ones that can really help members for the price that they're going to charge to be able to do that. So having your legal counsel or your tax counsel on speed dial is very important. And again, compliance on this front is key. I think as Jonathan was researching there a couple of weeks ago, could be some hefty financial penalties and even jail time involved if you're not reporting those correctly. So again, just remember the intent behind that. Nobody wants to go jail. The random Farm Bureau member who didn't report their small business percentages to FinCEN, but the goal there is to have some teeth to that law so they can sniff out the illegal financial activity that might be occurring.
Couple of the best in this space on the podcast with us from Wright and Moore, Ryan Conklin and Jonathan Cottingim. Thank you both so much for your time. Good to visit with you.
Thanks again, Ty.
Thanks for having us.
Hi, Brian Baldridge here, Director of the Ohio Department of Agriculture. Farmers, we need you to do your part for water quality. Thousands of farmers have already signed up in H2 Ohio, doing best practices that are good for the soil and good for Ohio waterways. Be a part of the solution, earn incentives, and doing the right thing for your farm. Contact your local soil and water district to enroll today. Thank you and have a great day.
Here in our state, there's an energy at work, a drive to help people live healthier lives with confidence. But it can't be done alone. That's why our healthcare, business, and community leaders have joined together to help people here feel more empowered by their healthcare, leading to improved long-term health and savings. A health plan for small businesses in the agricultural industry was created by the Ohio Farm Bureau Federation. It provides members the tools, resources, and financial protection to feel confident in their healthcare decisions. By sharing responsibilities, we help build healthier employees and communities, driving down costs, connecting members digitally to Anthem's diverse network of local resources, participating in health literacy, easing administrative burdens. Joining the plan means you're part of making healthcare work better, giving people the confidence to make anything possible. To learn more about how the plan can work for your business, visit our website or call your broker or Anthem sales representative.
The Ohio Farm Bureau Landowner Toolkit has been updated, and it's available for download now exclusively for Ohio Farm Bureau members at ohiofarmbureau.org. One of the topics covered in the toolkit is zoning. We bring in Leah Curtis, Policy Counsel with Ohio Farm Bureau, to talk more about it. Leah, what is zoning, and how does someone know if they have zoning in their area?
Zoning is a decision by your local government to organize the land uses within their jurisdiction. So that could mean certain businesses can locate it in one area versus in other areas, mainly for residential uses. Unincorporated areas, those outside of a municipality, they could have either township or county zoning. If you don't know, you could usually contact your township trustees, your county commissioners to find out. They can certainly point you in that direction. If you live within a municipality or an incorporated area, it's probably likely that you do have some sort of zoning that applies to your property. And again, you could contact your local legislative government, city council, to find out that information.
So what types of things does zoning regulate?
So zoning is typically concerned with the use of the land and the features from the outside. So aside from, can I use this property for a house, or can I put a laundromat on this piece of property, zoning is also going to look at things like building size or setback from roads or property lines. And it's important to note that this is distinct from other types of regulatory codes that we often get questions about too, like a building code or a fire code, that are more concerned with the actual structures or the safety and not just the land's use itself.
Even though there can be zoning in rural areas, are there limitations in the law when it comes to agriculture?
Yeah, so county and townships actually under state law are prohibited from zoning agriculture in most instances. So this means they can't prohibit the use of agriculture except in limited circumstances. Now, as with other areas of the law, we're talking about productive agriculture here, not necessarily, ancillary activities or businesses. But the law does say that it's not only agriculture, but also marketing and storage that's incident to the agricultural use of that property.
When can local officials apply zoning regulations to agriculture?
Again, there's going to be a very limited set of circumstances because generally they cannot prohibit agriculture. But if a lot is located in a platted subdivision or in an area with 15 or more contiguous lots that have been improved under certain platting provisions, then local officials can regulate agriculture on lots less than 1 acre. On lots less than 5 acres, they can regulate buildings or structures as to size, setback, and height. And then on lots that are less than 5 acres, where at least 35% of the lots have been developed, they can regulate livestock and poultry. So if you're in sort of that subdivision or that platted area, there will be a little more ability for your local government to limit those agricultural activities.
How often do we see these limitations apply?
So I would say these don't come up very often, and that's not necessarily because we don't have these situations, but it's because most of the time in a platted subdivision or some of these like individual lot situations, there's already property restrictions or covenants that were placed on the property at the time of sale. So, for example, if you live in an actual subdivision, it's not uncommon that you have a restrictive covenant on your property that says, you can't do this, you can't do that, you can't have a fence, you can't, paint your door without talking to your HOA. A lot of times those restrictions will include some limitation on agriculture, some limitation on livestock. And it's important, those are not zoning provisions. Those are specific to those properties.
There are a few other specific agricultural uses that townships and counties are limited in their ability to regulate. What are those?
So in all of these instances, local officials can regulate certain aspects of land use, but they're going to be limited. So for example, farm markets is one good example. If a farm market's making at least 50% of its income from products of the farm, then they can regulate the size of the structure, the parking area, the setback, the ingress and egress. So those are kind of things more related to public health and safety, right? Similarly with agritourism, they can regulate all those same things: setback, parking area, ingress and egress that may affect the public safety.
Trespassing, a concern that a lot of farmers and rural landowners unfortunately have to deal with. And today we're going to discuss this and the liability that comes when people enter your property. Leah, trespassing is a criminal issue, correct?
Yeah, so trespassing is what we call a fourth-degree misdemeanor. And then, of course, if there are any other illegal activities that might be happening along with that trespassing, theft, property damage, those kind of things, those may be additional crimes. But sometimes landowners get frustrated because it can be difficult for law enforcement to address trespassing, particularly if they, cannot catch that person in the act, so to speak. So it is always good to try to work with law enforcement, though, when you do have these issues. We want people to stay safe, and not necessarily confront those trespassers directly. So working with your law enforcement, documenting those instances is always a good help.
A lot of times people are concerned. They hear stories about trespassing and the landowner being sued for injuries a trespasser suffers. Do things like that really happen?
I would never say never, but those circumstances are pretty rare, but they become kind of urban legend and myth. Somebody was crawling on someone's roof and fell through and then they sued them. Under Ohio law, generally, a landowner doesn't have a duty to a trespasser except to avoid purposefully injuring them with intentional or willful misconduct. That means actually harming them directly. So this changes a little if the trespasser is known to you, though, and that's one thing I want to highlight. Either the trespasser is coming on regularly, maybe you've already seen them. You do then have a duty to warn them of unnatural and concealed dangers. In law school, this was the man-made bear trap rule. You got to warn them about those man-made bear traps. If you've dug a hole and put a cloth over top of it to catch a bear, you might want to let them know. But generally, again, you can't intentionally harm them. If you do have these unnatural concealed dangers, those might be necessary to be warned of. Otherwise, liability is fairly limited when it comes to a trespasser.
Does the law treat children differently?
Yes, and this is something that we hear a lot of questions and concerns about. Ohio law does follow what's called the attractive nuisance doctrine, which means We do give special protection to child trespassers in certain circumstances. Again, there's going to be a lot of urban legend around this, but basically the law says that you could be liable for injuries to a child trespasser if there was an artificial condition on your property that is dangerous but attractive to children. Now, this is not like an automatic thing. A court has to go through a number of factors to determine if liability was appropriate, including whether the landowner knows or had reason to know that children were likely to trespass. Did they know the condition had an unreasonable risk of death or injury? That the children that were trespassing could not understand the risk, that the need for the condition was slight compared to the burden of eliminating it, and then whether the landowner exercised reasonable care in eliminating the danger to protect children. So there are all these factors that go through. So the court would have to look through all those things before they determine whether there actually was liability in an attractive nuisance situation.
So what types of artificial conditions are things that landowners should be concerned about?
So the main example, the one that really solidified, created, where the court found attractive nuisance to apply, is an opened abandoned swimming pool. So in that situation, there was an abandoned swimming pool, was collecting rainwater, frogs and other critters in it, became a significant hazard. So open swimming pools, and again, cases like this are rare. But this is one of those times where you might want to look around for things that are not natural to land, things that you've added to the property and might have a really high risk of danger to children.
One of the questions a lot of people ask us is, how do I make myself not liable, or how do I keep someone from suing me? What can a landowner do?
So that is a very tough question, and we do get it a lot. They say, I want to remove all liability. That's very hard to do because, first of all, whether someone's liable is not based on there's not any clear-cut rule. It's going to be based on the individual facts of the situation. So there's not necessarily a checklist of do this and do that, and then you don't have liability. And then second, there's no real way to keep someone from suing you. We all have a right to the court system. And so the real question that I hope people can instead ask themselves are, where are there things on my property that might create a strong risk of injury? How can I reduce that risk? What are things that I might do to, limit that risk so then I can't be found liable because I've taken those steps? So is there a barrier? Would a fence make sense? Could I add a simple warning sign? Things like that can, in any situation, go towards the court considering that you've taken steps to prevent injuries and liability.
Are there at least some protections for landowners in the law depending on the circumstances?
Yeah, there's various defenses in the law that might be available depending on the situation. And so, again, we've already talked about adult trespassers. Generally, the law is going to say you have no duty to them. You don't have, you're not generally going to be liable to them. But even people you might have on your farm as guests or as business customers, there may be defenses if someone's hurt and tries to sue you. For example, there's a recreational user statute, which protects landowners from liability when they have allowed others to use their property for recreational things like hunting. There's an agritourism liability defense if a landowner has put appropriate signage up and someone's injured as a result of the inherent risks of agritourism activities. And so there are a number of defenses that do clear you from liability or prevent liability. And you just need to be aware of those, but also aware of what are those risks on your property.
People want to find out more about landowner liability. Where can they turn?
So our members can access the Ohio Farm Bureau Landowner Toolkit through our website, and we cover all of these type of liability topics, the different types of duties that you have to different people on your property, as well as some of those immunity protections that are available under the law.
Policy Counsel for Ohio Farm Bureau, Leah Curtis, joining us for this Legal with Leah. Appreciate it.
Thank you.